Chris, are we turned on or our mics on?
Yeah, they're a little low, just didn't want to.
Free charge, you take my folder yesterday?
Well, we want it to be recorded. So
Yeah,
turn it up so that Ashley and I especially have softer voices.
Oh, yeah.
Please make sure they can hear us.
Yeah, we will. We will, but I just didn't want this to turn on, right, this turns
I'll
on.
come and get you.
Cause the interference, I'll just.
Okay. All right, well, I'll do the opening part of this when we get to that. All right, good morning. I'll now call to order the Clay County School Board Workshop for Thursday, January 27th. Welcome to any citizens who may come in. We'll take this opportunity to thank you for taking time out of your busy day to attend today's school board meeting. This meeting is our opportunity as your elected representatives to collaborate openly and make decisions that will decide the future direction of our public schools and the education of our children here in Clay County. There will be an opportunity for the public to ask questions at the end of the workshop presentation. Your participation is welcome. Today we will be interviewing two candidates. The format for today's interviews will be as follows. We will introduce ourselves to the candidate, ask the candidate to introduce themselves for approximately 5 minutes to us. We'll then ask 10 preliminary questions of each candidate and allow them 3 minutes to respond. We will rotate as board and each ask a question. Once the preliminary questions are completed, we will open the floor for individual board members to ask any additional questions they may have. We will continue to rotate through the board one question at a time, so that all board members have the opportunity to ask their questions. At the conclusion of the interview, we will ask the candidate if they have any questions for us before they exit the room. At this time, we'll begin the first interview. Mr. Brodsky, would you like to bring in Mr. Bickner?
The door is closed. The door was open before, that's why it was showing. Getting wired for sound. Good morning.
Good morning, Mr. Bickner. Thank you for your interest in the position of our school board attorney. We appreciate your time and the time you've committed to this process and your willingness to come and interview with us today.
I appreciate being here.
I'm Janice Karakis, as you know, chairman of the Clay County School Board, and take this opportunity to let my fellow board members introduce themselves.
Carol Stutter.
I'm Betsy Condon.
Mary Bola.
Been
How you doing?
Ashley Gilhassan. And our superintendent.
Good morning, Addison Davis.
The format for today's interview will be as follows. We'll begin by asking you to take approximately 5 minutes or so to introduce yourself to us. We will then rotate through our school board members with questions, allowing 3 minutes or so for a response. We'll rotate through until we run out of questions or time. And at the conclusion, we'll give you the opportunity to ask us any questions you may have. So if you're ready, we'll begin.
Am I working? Am I like that? 5 minutes to tell you something about myself. In about 1998, sometime then, I was a medical malpractice defense attorney and traveled all over Florida and Georgia, Mississippi, Alabama, working medical malpractice defense cases, defending doctors. I was also involved in a lot of community organizations here at Children's Haven Education Foundation and others, all having to do with children. And as part of that, I was invited to a roast for Frank Scrooge. And you probably remember the roast. And it was downtown Jacksonville, and I went and I listened to Frank and listened to the things he did, and I'd known Frank for years and years, I just didn't know what he did. And after I heard that, I walked out of that and said, I want Frank Scrooge's job. He was going to retire in 4 or 5 years, and that's what I wanted to do. And so what I did was I learned everything that I could, in every way that I could find, to learn education law. I studied the statutes. It was before the change, before the education code came in, and it was a lot of it was case law. And so when Frank decided to retire, I put my name in the hat with some other folks and sat down and interviewed with all the board members across the street in the old boardroom. And lo and behold, was chosen to do that job on a part-time basis. When I started looking at what was being done and the money that was being spent, I kept kept going back to David Owens, and I kept coming back to the board and saying, you could save money if. And just started bringing everything into the board, bringing everything in-house. And when we brought everything in-house, the end result was we saved a bunch of money, because we didn't settle cases high, we didn't give money away. And the cost of paying the attorney that went to try the case was zero. And on top of that, I found a love of a community where I could give all of the services that I wanted to give to them and to everyone else and to children in general. And all of the things that I'd done in community organizations, and I found a way to do all that with school law. Working with teachers, working with bus drivers, working with the school board members, working with people in facilities, working with people in contracts, ESC, the whole gamut, because I was a one-man show, so to speak. And that has been my love in life. It was the biggest gift that I ever had, was to get involved in school law. And so I have continued to stay current in that and continue to want to do that. It's been suggested to me that there are places around the state that I should go and talk to folks. Clay County is my home. The people in Clay County are the people that I love. And that's why I have chosen to apply back to this and see if you'll have me. That's all I have to say about Bruce Baker.
Thank you. Well, we're glad you're here today. First question. What's the most difficult case that you won? And what is the most difficult case that you lost? And what would you do differently?
You have to understand in law, there's when you're talking about winning and losing, you're talking about things that often seem antithetical, because you can lose a case and win a case at the same time. The hardest case that I ever won was the last malpractice case I tried in Valdosta, Georgia in November of 2005, which was the month before I came on full-time here. It was a 5-day trial before a 12-man jury in Valdosta. And it was involving a man that had a stroke. He blamed the stroke on the medical care that he had received, the physician that had treated him. It had been an agonizing case to get to trial because there were experts all over the country. There was a lot of travel. There was a lot of medical stuff. It was very complex litigation. Right in the middle of the 3rd day of trial, the doctor in Jacksonville that I had retained as my neurologist expert called me on the phone at 8 o'clock at night and said, "Your theory of the case is wrong. Everything that I see, I have reevaluated. I've gotten new studies and new scans of the man's brain, and everything you know about this case is wrong." And so it's like, what do I do now? Do I keep going the way I've been going? Or do I walk in tomorrow and admit and say to this jury, everything you know, everything that I said to you in opening argument was wrong? And I chose to follow the truth. And so I went in, I put him on the stand, I explained to the other side before I put him on the stand, what you heard before and what you heard there are two different things. Tear him up any way you want to and come after me however you want, but I will not present something I know to be untrue. And Dr. Kogo took the stand, and he was magnificent. And when I cross-examined him about examined him about why he changed his testimony in the 11th hour, he was forthright and he was honest. And they tried to beat him up, and it didn't happen. And so at the end of that 5-day trial, the jury came back and said, "Your doctor didn't do anything wrong. The man didn't have a stroke. He had a different disease entirely that presents in a similar way." And so that was the hardest case I've tried. It was also hard because it was the last malpractice case I've ever tried. And I really enjoyed the medical aspects of it. So it was a very difficult case. The hardest case that I've lost, I'm going to tell you ahead of time, it's a, what did I talk about? It involved a child that died in school. case, we lost it, but we didn't lose it. I worked on the case and worked as hard as I could because the demand was $2 million. And finally got the case beat down to the point where it was $180,000 we could sell it for. And I took it to the board and they approved it. It was a loss because we had to sell it when I knew we were right. But it was a win because, in my opinion, I would have destroyed Orange Park Elementary School if we tried. The teachers were so distraught of the death of a 5-year-old child on his 5th day of kindergarten that it would have destroyed every person in the school that had to testify. And so that was the choice that we made was, do we roll the dice or do we settle for $180,000 when we know we can probably win if I could hold this group of 7 people together? And so we settled it. It was hard for me. What I would do differently on that case would be now, the day that the child died, I would ask the superintendent to allow me to go out and get involved with the investigation. Because there were things that were done by the medical examiner that if we had caught early, we could have had redone. There are things that were done in the analysis of the crime scene, or not a crime scene, but the death scene, that if we had known earlier and got involved earlier, we could have changed. And it would have given me a case that I could have probably defended and still would not have wanted to try, because the nurse in the case never was a nurse again. She walked away from the school that day and never came back. It was that devastating death. But it would have allowed me to have done a better job if I had gotten it.
Thank you. I know that was difficult. I'm sorry. We're just going to wait a second. Let Mrs. Steyer compose yourself.
It was painful. Okay.
Okay, you're up. Would you like me to ask the next
Yeah,
question?
go ahead, skip my question.
Okay.
Get everything.
Okay, that's fine.
I'm sorry.
What types of cases can we expect you to outsource? And then the second part of the question is, what type of oversight process will you put in place for these outsourced cases?
The only cases that I think should be outsourced is a matter of just policy or workers' compensation cases. And the reason behind that is workers' compensation cases, some of them last 30 years. And so you have a law that has changed every 2 years or every 3 years or 4 years for the last 30 years. It is so specialized that when I was working here before, we retained one workers' compensation lawyer that had been doing it so long that he knew everything about the changes in the law. And so he could go back and apply 1988 law to a 2010 case. Beyond that, the only cases that I would outsource are those things that are so intensely involved with a specialized area of the labor law that is beyond my expertise. In the past, and I'm talking about before 2008 or 2010, the way that we controlled that was I was co-counsel on every one of those cases. And so I attended every hearing, I attended every deposition, I knew everything that was going on in the case, and also kept a thumb on costs, because those things can run away real quick, especially when you're paying a labor lawyer $250 an hour. Beyond that, there were things that have been sent out in the last several years that I will not send out. EEOC cases, there was no reason why I handled them up until 2010 or 12. Other cases having to do with investigation of 1983 litigation and other types of labor things. The only other area of which I have zero experience is collective bargaining. And the reason is because no one ever went to collective bargaining except the school board members, the superintendent, and the finance guy. And so it's one of those things that I can learn really fast in a quick study. As I told the board when they hired me in 2000, I spend my own money to learn what I need to know. And so if it's something that you want me to pick up, I can pick it up. It may take me 6 months to get it. But other than that, I think everything should stay in-house. Everything should stay in-house. There this case, we want our assigned attorney to do this. And in those cases, I have always been assigned as co-counsel on the reports.
Okay, I'm ready.
Okay.
And I apologize,
No,
y'all. It's
you're
just,
good. That's good.
it was something the board really
I was a teacher during that time.
suffered through. Okay. How many years of legal experience do you have overall, and what do you consider to be your specialties? Do you have experience as a full-time school board attorney, and if so, for how many years?
I became a lawyer in 1981. So however many that is, 36 years. I started doing defense litigation and medical malpractice litigation in 1984, where I was a prosecutor as a state attorney. I have, if I had to say what's my specialty, I can't legally say I have a specialty under the, but what I've done the work in, most work in is school law. And every kind of tort litigation there is, including mostly medical malpractice, but any kind of litigation there is, plus school law. When I say school law, it's such a broad thing, I don't know how to define it any other way than that. Every aspect of the school law in this district, I've had my hand on at some point. So those are my specialties, will be school law and litigation.
And how many years as school board attorney?
I was hired as a part-time attorney in 2000, and after I brought everything in-house and we sat down and looked at it was going to cost more money to pay me outside than to bring me inside, I became a full-time school board attorney in 2005, and I left December 2015. So 10 years full-time, 5 years half-time.
Thank you.
You have to excuse the noise out there, they're going to.
We're not sure what the party is, but obviously.
Sounds like there's a
we're
party
invited.
without us.
The party we didn't know about.
Question number 4. How do you plan to manage situations when the school board's priorities differ from the superintendent's?
There sometimes is a thin line that you walk, especially if you're doing inside work. As I told the board when I met with them in 2000, if I'm hired as this job, I am the school board's attorney. My client is this 5-member board sitting here in front of me. My allegiance is to the board, not to any individual, to the board. And if there comes a time when I see that the board's interests are divergent from those of the superintendent, I go with the board, and I advise the board, and I explain to the superintendent that I cannot advise him in that area. That has happened a few times in the past, but not a lot until the last 2 years that I was here. Before that, usually I was able to find a way to bring board and superintendent close enough together that I didn't have a conflict of interest. But my allegiance is to the board, and my advice to the superintendent is I cannot help you with this.
Thank you.
Chris, could you turn Mr. Goodrich microphone?
I'm sorry.
And you're good, it's just, can you turn it up so
Yep.
when their noise is coming through the wall, I'm not hearing everything? Thanks. Sorry, Ashley, I didn't mean to interrupt you.
That's okay. Are you ready?
Yes, whenever you are.
How do you view the school board attorney's role in providing counsel to individual board members? How would you handle requests from individual school board members?
That depends on the board. In the past, it would be not uncommon for Carol Valencourt to call me and say, I need you to answer a question for me. Or for Mickey Fields to call and say, I need you to answer a question for me. Or Lisa Graham did it a lot. Can you tell me, I want you to find me an answer to this and get back with me. It would be smart if every time someone asked me a question, the question was posed to the entire board and the answer was posed to the entire board. But again, that depends on the board. If that's how you want it, then that's how it would be. If it's left open, then it's left open. The problem is sometimes a sunshine law issue, because if someone calls me up and asks me a particular question, then for me to frame it in such a way that I can pass it on to the board, I'm going to have to change the question and change the input that I got from the question in order that I don't violate sunshine. But again, that depends on the board. If it's something, there are some things that I gave answers to that came to me in an oblique way that I would just send out my answer to the board and the superintendent and all the administrators, because it was of such import. But if it's been specifically asked to me by one board member in the past, then oftentimes I would just answer one board member. But it depends on how you want it done. I think that if you do want that degree of openness and complete dispersal of information, I think you need to make it a contract term. So you have to do that, you have to make it a policy. And teacher make it a contract term.
Thank you. How do you ensure that you remain the school board's attorney and not part of the district team? How would you remain objective when dealing with legal issues?
I'm sorry, I couldn't hear the last part.
How would you remain objective when dealing with legal issues?
Between the superintendent, the district team, and the board? I think it's similar to what I previously said. If you look at the experience that I had with the district, it covered pretty much everything you could do. And the reason it grew to that was because it seemed to make sense to save money and to make things more streamlined, to work better with teachers and administrators and guidance counselors and ESC people and all of that, than to have an assortment of different people trying to give input. The only time that I see that as a problem is when the team's idea diverges from what the board has made known in the past that they want to do, or when it violates or comes into conflict with those specific duties that are set out for the board. Florida Statute 1001.41, 42, and 43 say the school board shall, or the school board may, or the school board, whatever. 1001.51 says the superintendent's duties are limited to this. And so if there's an incursion into those things, then I think there's no question that you have to divide a legal line. If there's no conflict, if there's no diversion or incursion into that, then I don't see that there's an issue that has to be made. But from a legal standpoint, if the team idea comes in conflict with the board's idea, then I'm going to have to draw a line there. And again, without to inform the superintendent, I can't advise you here, number one, and number two, I can't do what you're asking me to do. That's simple.
Thank you.
That's it? Okay, this is a long one. They give me the long ones. As a school board, we deal with a wide range of legal issues unique to education law. I'm going to go through a list of issues you can expect to face if hired. How many cases have you previously handled relating to, and I'm going to go through the list and then I'll go back to them individually because it's too much to remember. ESE students and the development of IEPs, issues pertaining to student due process, bringing or defending against Section 1983 civil rights actions, student discipline issues, the McKinney-Vento Act for unaccompanied children, educational accommodations related to disabilities or other special needs, issues related to FERPA, the Federal Education Rights Privacy Act. The question is, how many cases have you previously handled relating to this list of items?
What was number one?
The first one was ESE students and the development of IEPs.
When you say cases, that's kind of a misleading term. Cases to a lawyer means lawsuits.
Okay,
Um,
I'm talking about just
Handling issues with that.
ESE issues
Okay.
and IEPs.
With ESE issues and IEPs, every time there's a lawyer or an advocate involved in the past, I would be involved in the ESE process and come to the IEP and whatever meetings were with the parents, the advocate, or the lawyer. So the number would probably somewhere upwards of 100 and probably less than 100, and probably less than 200.
Okay, student due process.
That's countless.
Countless.
Probably, I would say 300 or 400, 500. Because every time you have any kind of issue with assignment, discipline, dress code, whatever, it's always a due process issue.
Section 1983 civil rights actions, bringing or defending against the law.
I can't imagine a circumstance where the school board would be bringing something like that, or government agency would be bringing, but defending against 50. Right now, I have 30 ongoing 1983 civil rights cases, 15 of which I'm sole primary counsel, and the other 15 I am co-counsel.
Student discipline issues.
Not counting the ones that came before the board every month, probably 2 or 3 a week for 52 weeks a year times 15.
I just want to put
it's
it up.
hundreds, yeah. Those that came before the board vary, but a lot, several hundred.
The McKinney-Vento Act for unaccompanied children.
That only came as a product of the recession. And so you had a lot of children that were migrating with people that were not family members. And so that's how it came to be.
Educational accommodations related to disabilities or other special needs.
Probably between 90 and 150 under Section 504.
Okay, issues related to FERPA. Federal Education Rights Privacy Act.
Probably 5 or 6 per week for my entire tenure. So that would be several hundred.
I'm not going to multiply. Thank you, Mr. Bittner. Okay, next.
How would you expect to interface with other state and local government agencies in your role as a school board attorney?
When I was a school board attorney, and I would probably try to handle things the same way that I did at that time. The government agencies that I routinely interfaced with were the county commissions, the governments of Penny Farms and Orange Park, the community development districts for numerous of the communities because they are a government entity and agency, the Clay County Utility Authority, and the Florida DOT. My first line of defense, my first inroad into that, the way that I maintained a relationship with that was to maintain a relationship with their lawyer. Each one of those agencies has a lawyer. And so if I know the lawyer when we have an issue, and if he knows that I shoot straight, don't lie, and deal directly and fairly, then I already have an inroad to those community district supervisors. The other thing that I did with Green Cove Springs, with Orange Park, and with the county was to know their managers and work with their managers so that anytime an issue came up, and that was usually done in the course of dealing with that through the facilities administrator, whoever was in charge of dealing with building schools, renovating schools, all of those things, because that gives me one more level of person to deal with that knows me and that I know. Beyond that, to the lower staff, generally you don't get involved in that because it needs to be more lawyer to lawyer or lawyer to senior administrator or senior administrator to lawyers. So it always worked well with lots of contracts, resolutions, and things like that. that's how I would do that.
Seems redundant, but what types of cases have you routinely handled for school districts in the past?
By cases, you mean issues,
Cases,
lawsuits, or issues?
it says cases. So I'm going to assume it's cases,
Okay.
not issues. And it says routinely, so were there cases that came up, routine type cases?
The
that were-
lawsuit type cases that I routinely handle were
Mhm.
civil rights issues with, my daughter didn't get to be on the cheerleader team, we discriminated because she's from Puerto Rico.
Mhm.
Children that were injured in sports, one in particular, they were playing baseball practice and multiple balls were going around and a child got hit in the side of the head. Shop class, we had one where a nail went through a child's eye because he was playing with it to see how far he could skin the nails across the room. Another shop class where they took the thumb off.
Was that a teacher or a kid?
Well, they were showing him, the
I
teacher
know a
was,
few
the
teachers who
teacher
had
was,
problems with that.
it was a kid that happened to, but they took the guard off the saw. So, you know, and they ran it through and took stuff. Bus accidents by the dozens. Other kinds of cases. Most of them were personal injury cases of one sort or another. A few contract cases. There was a case that was brought in federal district court in Jacksonville by a contractor in Alabama because we had backed out of a contract without meeting the terms of the contract.
Do you remember how that one came out? Just out
Pardon
of
me?
curiosity. Do you remember how that one came out?
We paid $30,000 out of a $250,000 contract. And, but it was one where there was communication, before it even got to the contract though, the communication was from a lower level administrator in facilities committing to entering into a contract. The contract never got awarded. But then the Alabama contractor changed position and bought all of the cabinets, all of the kitchen facility stuff. It was in a kitchen rebuild. Carol probably remembers that because we mediated that case. We settled it, the loss was measured to be about $200,000. We settled it for 30 because we said you can always resell what you have stocked. So we also forced it out of federal district court into local court because I'm better off with the sitting judge in Clay County than I am with the federal district judge in Jacksonville. There were a few other contract cases. There were a couple with, when we built the schools that came up where we had to pursue those. There were several ESC cases that went to litigation. I won't say several, I'll say 3. Beyond the DOA hearing, beyond the due process hearing, you want to file in the federal district court, because you have the right to appeal beyond that. Those were primarily the types of cases.
What do you think makes you the most qualified to be the Clay County School Board Attorney?
Most qualified presumes that I know the other people that are participating.
Well, let me rephrase it. What makes you uniquely qualified?
I'm uniquely qualified, I think, because I have done it and have done every aspect of it for so long. When I was thinking about this morning, I was offered, someone said, we would like you to come down and interview for a job in so-and-so, and I said, well, I don't want to do that because I'll be in a department. There are 20 attorneys in the school district, and I will be sitting in one spot doing one thing for every day, sitting all day. And most of those lawyers that I know from school board meetings don't know a broad area of school board law because they've been doing the same thing forever. I was lucky to have had really good teachers. I was lucky to have had Frank Scrooge as an excellent teacher, but I've also been to every Florida School Board Attorneys Association seminar and meeting for the last 15 years that I could go to. They're 4 times a year. And so I have taken over 300 hours of classes and courses that taught me things that were useful in everyday life. And then I came back and applied all those things. And so I think that my qualifications are unique because I have a very broad scope, because I have a lot of depth in litigation, I have a lot of depth in mediation, because I am a certified mediator. I have a lot of depth in handling ESC cases, because I've done so many of those, and I've had really great people here at ESC that have helped teach me stuff. And I was looking at this last night and thinking about it, and I pulled up the job description that you have online. And it was written in 2005, and that was the first year that we had a school board attorney in-house, and that was me. And I sat down with the superintendent and with the chairman of the board, and this job description is what we came up with. And I have extensive experience in every single aspect of the responsibilities and required qualifications for that.
So you participated in writing the job description?
I and the school board, or the school superintendent, and the school board president, chairwoman, sat down and said, these are the things that we do, these are the things that we expect you to do, these are the things you've been doing, and these are the things that we're going to have you do every day. And so, to the extent that I had done those things, yeah, I participated in that. It was a new position at the time. They never had an in-house attorney. And so when they looked at the things that were going to be the qualifications, they looked at all of the things that they could possibly get an attorney to do. And that's what it came. That's how it came in. The only other thing that I say makes me uniquely qualified is I love every aspect of school law. It is my way of giving of myself. I don't do anything else really well. And so the rest of the world is on its own, but school law, I take the helping that I can with educating tomorrow's children. That's my qualification.
Madam Chair, may I ask something? Who was the chairman at the time that you wrote that job description? Who?
Carol Dunn,
Okay, I was trying to remember back who was chairman back then. Carol Valencourt?
I
Okay.
believe so.
Well, I don't have any additional questions at this moment, so if the board has additional questions they'd like to ask, we'll go to group.
I'll pass right now. I may think of something in a minute. Okay.
What additional resources do you expect to be provided? It's no secret, we've had budgetary constraints and things like that. So what additional resources do you expect to be provided?
The only thing that I really think that I need to have available to me is Westlaw. The reason is because the law changes rapidly, and because through Westlaw I can get every case, federal and state case, within days of the time the opinions are rendered, and I can get all kinds of other resources because it also has Florida jurisprudence and things like that. So it's sort of an essential to practice law. Otherwise, I can go down to the courthouse and use the one in the basement. It's a long ride.
I'm assuming a paralegal or assistant?
No.
Huh?
I worked for the Attorney General's office, and I found very quickly that they do not have paralegals or assistants. And so I have learned to fly on a computer.
Impressive.
All of the writing samples that I sent you, the things that I have done in federal court, I typed them in my own.
Your own digits.
You're taking my husband 2 years.
Tell me,
Answer mine.
tell me about your board certifications from the Florida Bar, and how you expect the district to benefit from those certifications.
Board certification is one of those unique things that I am eligible for and have not pursued. I'm eligible as civil trial certification, I'm eligible for education certification. I have not done either one because I didn't see that they made me a better lawyer. When board certification for education came out, about 7 years ago, I could have been grandfathered in without taking the test. I chose not to be because I wanted to see how it shook out, how it panned out, what it came to mean. If that's of importance to the board, you can make a determinable appointment that I can do that and be certified within 2 years. The reason 2 years is because the next board certification test that I could sit for would be March of 2018, and you have to apply by August of 2017. So I'm too late for the March sitting in 17. I did the same thing with civil trial law, because when I looked at it and looked around at the people that I was practicing law with, I didn't see that it benefited me in any way, because it doesn't change how I practice law.
Do you want me to ask my next question, or let's move on?
So, did you have another question you want to
Not
go
right
through?
now. Just go.
Could I add one other thing about certification?
Of course.
The only people that are really certified, the primary number of people, there are about 55 people that are certified in the state. They're all members of the Florida School Board Attorneys Association and work as school board attorneys. They are my comrades and my associates. There are 2 or 3 people that I know that are certified who got certification because they're pursuing a specific area. One, as an example, has a child that's an ESC child. And so she started getting into the ESC to try and help her child, and in the process figured out that she had a niche where she could represent ESC parents. And as an advertising tool, she became board certified so that she could put that on her resume and on her advertisement on television or whatever. And so she is a very smart, bright lady who is board certified, but knows one area of school board law and knows it very well. That's what she knows. There are 1 or 2 others that have done the same thing. One I know has done it with charter schools, because he wanted to say, when you represent people in charter schools, I'm board certified in education. And there are 1 or 2 that do nothing but EEOC law dealing with school board issues for labor. So when you ask about board certification, you need to really ask about what they do, because oftentimes they're certified, but they're not experienced.
Well, I was asking about your certification and experience, nobody else's. Does anybody else have a question?
So it's kind of a twist on a question you were asked before. I can't remember who asked it to you, but it's kind of a twist on the question about the school board and the superintendent. So how would you handle if an individual employee approached you for counsel?
On a school board issue?
Right.
Well, that depends on the school board's policy, and it depends on what the school board issue is. If it's something having to do with an individual's, how do I phrase it? I gotta think about this. There are lots of times when individuals can call me from around the district, setting at ESE teachers, principals, phys ed teachers. How do I handle it? This is what's going on, tell me what I should be doing, tell me what to do. If it was something that needed to be referred to their supervisor, I would say, this is something that you need to get from your supervisor. Usually, if you're a teacher, you don't need to be talking to me, you need to be talking to your principal. But if you're an assistant principal, and I say, this is something you need to talk to your principal about, they would say, I've already done that, he told me to call you. If it's somebody that's an individual that's calling up and saying, I'm having so-and-so problem with so-and-so person or so-and-so, my first response is, you need to talk to your supervisor. If it's a legal issue that has to do with some claim that you're going to have against the school district, then you need to talk to your own lawyer. You need to go find a lawyer or someone else. But I can't help you with that. Because I may in all likelihood end up representing the district through the school board. And so I would have a conflict of interest, and so I don't want to know about that. And so that's my initial response. Okay, and that's happened a few times where somebody's called up and said, you know, I'm being picked on and I'm being discriminated against, and I say, stop right there. You know, go look at the phone book, go pull it up online, call a lawyer, but I can't help you with that, because if you sue, under Florida statutes, you have to sue the school board, you can't sue the individual. And if the school board gets sued, I represent the school board.
Do you have a Martindale Hubbard rating, Hubble rating, sorry?
I have no idea.
90?
What was your answer?
I don't know.
I was gonna ask her ahead. Sorry, I was still writing.
Oh, that's okay. How many school districts have you represented? I know Clay County, but any others?
This is just for something, yeah, some sort.
Can you hear me now?
It's just a little fuzzy at that time.
You. Is it turning on?
Sorry.
So just Clay County?
Well, I'm sorry, what did you say?
I asked how many school districts he's represented.
Only click on.
Mrs. Studdard, do you have any additional questions?
I'm thinking.
Am I on there? Yeah. Thank you.
I do want to ask you something, Bruce, because I think it needs to be, Mr. Bittner, excuse me. Because I would like for it to be explained before this board. I think we have a giant fly in here. Buzz. Something was said the other day at a meeting that you had cost the district $150,000 due to something that you, I don't know if it was inferred that it was done incorrectly or left or what, but it was on, I don't even know what case it was on, but that you had cost the district $150,000 unnecessarily from something that you did or didn't do. And I don't know if it was in the transition when you were leaving and the next attorney was coming in, but can you recall anything that would relate to that? I don't even know what case it's about. Excuse me?
I would need more information because I don't know what you're talking about.
Ms. Hyman, would you explain what case you were talking about?
I don't have that information with me.
Okay.
It's not on my list of questions. I'm asking the same questions of
What
each
kind of
candidate.
case was it?
I do not know, but apparently it was the statement was made that it gave the board the impression that it was due to something that you did wrong or incorrectly or didn't handle, and that when the next, Mr. Sykes came in, that he handled it, but that if you had handled it correctly, that it wouldn't have cost us $150,000. Do you have any idea what you're talking about? Because I do not know. Excuse me?
I'll be happy to talk about it, but it's, to coin Ms. Condon's term, it's like picking an old scab.
Oh, okay.
You're talking about the Kerry Hollenbeck, Paul Hollenbeck case, is what I think you're talking about. When I was handling the Hollenbeck case, he was the man that came into the school board meeting and stood at the podium. He was represented by an attorney and started wanting to talk to the school board and complain about his daughter had been injured as a cheerleader. Got the case we're talking about? He then dropped the case because nobody would talk to him, and his lawyer, I had beaten his lawyer down so that he was going to lose the case. And so he fired his lawyer. And then he came in, and if this case you're thinking about, he wanted to try to settle the case himself. Rather than talk to me, Mr. Van Sant got involved in the case to try to settle the case himself. At some point, it reached some level where it could possibly be settled, and Sharon Ellis came to me and said, we can settle this case, what do you want to do? I said, you need to have a release, and the release needs to include the teacher, the young lady who was from the University of Florida, who was teaching the cheerleading class. Because she was cooperating with us, and to leave her hanging out there, she was our key to the case. She was the way we would win the case, and so we could not leave her hanging out. And I had already told her that we would represent her. I drafted the release, the exact same release that I have used for 35 years, that said, we do not admit negligence. We are settling this case as a matter of convenience. I gave that back to Ms. Nellis, and that's the only contact, after the board meeting, where he came in and the only contact I had with the case was to hand a release to Ms. Nellis. I sent it to her by email. And I knew nothing else about the case until sometime after I had left. And when I left all of my files in the office upstairs. I sent an email, an 11-page email to Mr. Sykes, to George Copeland, to Sharon Nellis, and to Mr. Van Zandt, explaining every detail about the case. And in each case file, I left all of my notes, typed and handwritten notes. I got an email from Ms. Nellis a week and a half or 2 weeks after I left saying, I can't find anything. Did you have anything ongoing when you left? And so I said, I sent her the same email that I sent out before. I said, the files are upstairs. Whatever happened to the Hollenbacher case happened without my input, because, and I'll tell you plain, and I don't like talking about this, it really upsets me. At that time, no administrator and no member of this person down here would talk to me because they were afraid they would be fired. And so once I handed everything over, or once I walked away from it at the school board meeting, I never knew after that of anything that went on with that case. Because it was out of my hands. It was in Sharon Nellis's hands. Now, Sharon Nellis was given a dirty deal because she was a secretary. They fired the risk manager to save money. And they said, okay, Ms. Nellis, you are going to be in charge of risk management. This is a secretary who had never done anything whatsoever to do with risk management. And so how she handled things was beyond me. I was not asked to participate. And so what happened to the Hollenbacher case happened between Sharon Nellis and Mr. Hollenbacher, or Sykes and Mr. Hollenbacher. But I'm going to tell you one other thing, and I don't, again, the person who has told you that I did something wrong is the same person who told you that you're not governed by the Administrative Procedures Act. He's the same person that stood up at the county commission meeting and said, for you to attend a county commission meeting is a violation of the Sunshine Law. He's the same person that said that you don't have to publish meetings when you're in certain ways. And he's the same person that told you, Ms. Karakas, that you have no right to all of the bills for all of the attorneys when they are under a case from the Florida Supreme Court. They are a public record and cannot be withheld. So whoever told you the things is the same person who's giving you all of that information. But I had no input in the case and how it was handled.
Well, I hated to bring it up because I don't like to pick it a scab. Sometimes we need to shut the door and go on, but I felt that I did not know, and I have not had any conversation with you at all about it, but I wanted to know the other side of the story, and I appreciate it.
And I appreciate that, but I think you and I have, when I was handling cases, I had every case that I was handling, I brought to the district before anything was done with it. And every case that we mediated, I brought in the board chair, and we talked about it, and then we went to mediation. And we paid nothing on cases for 15 years, except for the death case, and one case where a man shattered his knee when he was hit by a school bus. But the rest of them, well, that's not true. There was a man who got hit inside the head by the school mirror, school bus mirror, because the school bus was doing 55 and a 20. and just didn't see them. But other than that, we paid pennies on the dollar. So as far as what happened in Hommacher, I take no responsibilities because I was not allowed to participate.
Ms. Conlon, did you have anything further, Ms. Bolden?
I'm
Ms.
good.
Gilhousen, it's all you.
I'm finished.
You're finished. All right. Mr. Bickner, thank you so much for your time today and all the information you provided for us. Did you have questions that you wanted to ask us? Was there anything else you wanted to share with us?
No, I really appreciate the opportunity to be here. In my morning meditations, my meditation each day is that I will see the world new each day, and that I will see each person new each day. Ms. Conlon, you don't know anything about me. Ms. Gilhousen, you don't know anything about me except what you've been told by other people. I don't know anything about either of you except what I've been told by other people. My hope is that you will see me as a new person and treat me as someone about whom you have no information other than what you can see with your own eyes and experience. There was a rough couple of years there, and I think there was a lot of ugliness, and I think that we should be shed of it. And so I would appreciate your seeing me with new eyes and your own eyes rather than someone else's. And that's all I have to say, and I appreciate the opportunity to be here.
Thank you.
Thanks, sir.
Thank you, sir.
Appreciate it.
Mr. Baker?
Oh, Ruth. Mr. Bickner. Hey, you're supposed to shake our hands when you leave.
Good to see you all.
How dare you? If we were so bad, you were so bad. Good seeing you.
I thought it was time to
Well, thank you.
This was Kelly's story. What time's the next one?
We have time to do that.
11:30.
We have a little time next door.
What's going on over there?
I was just wondering.
They're both less They haven't.
Were they having a cheerleader
There were
round?
three people in the
What?
room, there were three people in the room talking about what they're seeing and what they're like.
What do they have to yell about
So,
it?
Mr.
Can we adjourn until the next candidate?
All right, we will adjourn for a 30-minute break.
Thanks.
So Mr. Rossi walked around trying to find them, I'm like, oh, there's got to be the roads here. So I was like,
Hey there.
How are you?
Morning.
Hopefully, you're saying this is the end of 2 days of dreadful exercise.
Oh, we're having fun.
Nothing like meeting with warriors for 2 days straight. Forgive me, I grew up in Gilroy, so if I sound country, it's because I am.
Well, good morning,
All right.
Mr. Poole. Thank you for being here today. We appreciate you taking the time to commit to this process and your willingness to come and interview with us. I'm Janice Karakis. I'm the chairman of the Clay County School Board. I'd like to take a moment and allow my fellow board members to introduce themselves.
I'm Carol Stutter.
I'm Betsy Condon.
I'm Mary Bola.
Ashley Gilhousen.
And this is our superintendent.
Good morning, Addison Davis.
So the format for the interview this morning will be, can you hear me, Chris?
I can hear you.
Sorry, I looked away. We'll begin by asking you to take approximately 5 minutes to introduce yourself to us. Then we will ask questions, we'll go through the board and just rotate till we run out of questions or run out of time. We'll give you about a 3-minute response to each. If you go over, not to worry, your time is ours. And at the end of it, we'll give you the opportunity to ask us any questions you have. So if you're ready, you may begin.
Sure, I'm a lawyer, so I'll try to keep it brief despite that. I can say that, my dad was a lawyer, so I grew up, basically in the profession. I grew up in the sticks in Gilroy, Florida. My dad was a lawyer in Jacksonville. My granddad was a chicken farmer in Gilroy. Went to grade school in Jacksonville. Went to college and law school in Macon, Georgia. I'm married. 13-year-old daughter of Darnell Cookman, who is being challenged greatly by the academic rigor. I've got a soon-to-be 32-year-old son who's up in Gainesville, Georgia, who's, despite my advice, became a lawyer anyway. And there it is. And I know you have the information in front of you, so I won't belabor what you can read. To address a couple of things real quickly, number one, to use, and I've taken the liberty of watching a couple of board meetings, that have been archived, and to use your words, I do believe that I'm a first-round draft pick. I'm board certified in education law. There are only 51 out of 85,000 of us statewide who are licensed to practice law in Florida, which is much too many. 51 of us are board certified in education law, which obviously is directly applicable. So I had to take a day-long, dreadful exam to demonstrate that I know about not only labor and employment law, but a bunch of other stuff that deals with education. I'm also board certified in labor and employment law, which I think Mr. Brodsky would probably acknowledge he has, from an HR standpoint, and I say this to people all the time, probably the toughest job in HR in the state. Because with public schools, with public universities, you've got unionized workforce, you've got tenure, you've got the full panoply of state and federal discrimination laws and whistleblower laws, and you've got federal constitutional issues as well, all of which I've handled both at the Attorney General's office on behalf of huge statewide agencies like the Department of Corrections and school districts in St. Johns County, Union County, Nassau County, and Santa Rosa. I've handled not only the labor and employment stuff, but also, and I tried to put this in the material that you have, a wide variety, because as you can imagine with like Nassau County, for example, there are a lot of things that come up. They don't have in-house counsel, so I get the call, and have for years and years. Whether it's Public Records Act requests, I've handled a Title IX compliance issue for Santa Rosa, and so forth and so on. So I think I'm a first-round draft pick because of my experience, because of the things that I've demonstrated through my accomplishments, and that I believe I'm a total package, to use another term that I heard, because I not only have knowledge of the legal issues, what I bring to the table, I think that others may not, is litigation experience. And I've taken the time to look at, for example, federal lawsuits in the last 5 years that this county school district has been involved in. 3 of those 5 cases are cases exactly like I've handled, personally, as lead counsel. Whether it's a lawsuit brought by an injured foster child against DCF and its employees, which is similar to a case that was involved, this county. First Amendment cases, of course, I'm handling a Section 504/ADA case right now on behalf of the University of South Florida, brought by a student saying I wasn't given accommodations. Administrative hearings, I've dealt with the union stuff. I know the attorney who's represented the school district. He's in the building next to us. We're both on the executive council for the labor and employment law section together. Eric is a phenomenal attorney. But I'm familiar with these issues. State case 119, there was a state lawsuit. I've handled that. So I think what I bring to the table is not only a knowledge of the rules, of vast variety of issues that apply to the school district, but also the litigation experience that I bring to the table, because you'll be looking to somebody who fills this position to give you advice and counsel on things that either will go into litigation, could go into litigation, or in it already. And I would submit to you that the person who is best able to do that for you is somebody who's been in the trenches and done it themselves. If you look at the federal court docket, I've appeared in probably about 100 cases in the Middle District of Florida, the Northern District of Florida, the Southern District of Florida. And that's accessible. If you look at state court dockets throughout Florida, I've probably been involved as counsel as many. So that's it. I'm sorry if I went over 5 minutes.
Don't apologize, you're fine.
I'm used to oral arguments where I'm looking for the light. You know,
We thought about that.
so, believe me, for lawyers.
We didn't want to intimidate. All right, question 1.
Yes, ma'am.
What's the most difficult case that you won? What is the most difficult case that you lost? And what would you do differently?
To me, every loss is difficult. It is extremely difficult because I'm invested in those cases. I live them. I get to know people. I care about them because, you know, in most of my cases, a reputation is at stake. I'm sorry, I'll sit back to avoid the
He's
feedback.
quick. He's fixing it.
It's fine.
So all cases are difficult. I had one that really sticks out in my mind where somebody who was an executive at a privately held corporation, or publicly held actually, got sued by the SEC, the Securities and Exchange Commission, for insider trading. They got fired for that. They were a vice president. They brought suit against the employer saying, I am being sued by the SEC in Chicago by reason of the fact that I am an official, or was an official, of this corporation. And therefore, the corporation owes my attorney for my defense under this indemnification provision. There was a case, we argued that, and there was a case that was not good for us out of Miami, and we had to try to argue around that to the judge. After the argument, but before the decision came out, the Florida Supreme Court reversed that, which went in our favor. Nonetheless, the judge did not want to agree with us. We were dealing with local attorneys, a local judge, and they're good people. But I think, you know, there was a problem. There was a reluctance to leave the local attorney high and dry without fees. That was a very difficult one. The most difficult case that I've won, probably University of South Florida case that I had where a professor was suing, having claimed that they were denied tenure because of their race. That was a difficult case. We won it on summary judgment before we got to trial. What would I do differently in both cases? I don't know. Because I try to turn over every stone. I guess there's always something that you can do to improve on your deposition techniques. In the case that I lost, we kept track. We knew that that case was pending in the Supreme Court. I looked at the docket almost every day to see when it came out. And the day it came out, I saw it, and we got it over to the judge. So hopefully that answers your question.
It does. Thank you. Thank you. Mrs. Cedric?
Okay. How many years of legal experience do you have overall, and what do you consider to be your specialties? Do you have experience as a full-time school board attorney, and if so, for how many years?
Okay. Licensed since 1993. 1993, so 23 and a half years. I hate to think that I'm getting that old, but I started working with the Nassau County School District. That's my earliest recollection of doing school district work. Now, our office also does St. Johns County. Our office also does Santa Rosa and Union. So from time to time, I've been involved in matters for those other school districts. Probably have been most heavily involved in Nassau, and that's been about 12 years. That was under Dr. Ruiz. I don't know if anybody knows John Ruiz, who's now retired.
I spoke to him.
Okay. I love the man. He's a wonderful person. Let's see.
Now, are you their school,
No.
you're their school board attorney, or did you do labor and employment law with them?
Did labor and employment law, but I am friends with the school board attorney,
In
who's Lynn
Nassau?
Hackett.
In Nassau?
Yes, and so I have been involved, and because it's a small county, they don't have anybody in-house, I've been involved in a variety of things that, you know, I get calls every week on, say, for example, Public Records Act request. I've got something going on right now where a TV station wants a video from a school bus where somebody, you know, an employee did wrong thing. And we're saying, look, for two reasons, that's not subject to 119. It's FERPA, and there's an Orlando case involving a city bus, when they said videos from the city bus are part of a surveillance system exempt from 119. I do a lot of stuff that isn't the labor employment, but as you know, the way the system is set up is somewhat awkward under the statutes, in my opinion. You can't have the same attorney act as board counsel and as the prosecutor, so to speak.
So do you kind of work with the superintendent?
I have
rather than
worked with
the
the
school board has an attorney, and then you kind of work with the superintendent?
Right.
Oh,
But I also get called in a lot by people in Nassau County on non-labor employment law issues. And, you know, we also, a partner of mine down the hall is general counsel for FSDB. So I'll have helped them from time to time. They have to make rules under the Administrative Procedures Act and have to go through this rulemaking, so I've assisted on that. So to answer your question, technically, board counsel, no. Have I worked with a board? Yes. And Kathy Burns, Dr. Burns, who is now the superintendent in Nassau County, she was on the board from before I started doing work there, which was 12 years ago. She resigned to run for superintendent. So she could attest as to, you know, her perception both as superintendent and as a board member.
Oh, okay, thank you.
Thank you.
What types of cases could we expect you to outsource? What type of oversight process will you put in place for these outsourced cases?
Okay. There are two instances I can think of where I would have to outsource. And there may be others that just don't come to mind. One would be employee termination cases. Teacher terminations, for example, they have a right under 1012.33 to request an administrative hearing. This board can either kick that over to DOA or it can hear those hearings itself, as you all know. I could not, on the one hand, sit as board counsel and advise you on those proceedings, and at the same time be the prosecutor who's acting as an advocate for the school district, because the Florida appellate courts have said that's a conflict of interest. So in that sense, that is one time where someone else, whether it's somebody who's already, and I don't know historically how this district has done this, but someone would have to prosecute that case, and I would act as board counsel. And the reason is ultimately the board makes the decision. So I can't do both. The other would be if there's, and I know there was an impasse hearing or hearings, actually one of the writing samples I submitted to you deals with an issue that another school district dealt with. Mind you, I was writing as an advocate, not as a neutral. So forgive me if you don't agree with the opinion. I was writing on behalf of the superintendent, not as I would write it necessarily as a board counsel. But impasse hearings, I do not believe I would be able to handle. And again, the reason being somebody's got to present position. And I know Eric Holzhauser did that in the most recent event. And then I would have to act as board counsel. So I don't believe I'd be able, I've never seen any case that directly addresses that scenario, but I think that that would hold true. Any other case where it's non-administrative, where the board is not having to make the decision itself, I can handle. And I've taken the liberty of looking, and I don't know what type of insurance the school district has. For example, on civil rights cases and employment cases, I know if you don't have insurance for that, it's an arm and a leg for an attorney. You know, $3.50 an hour is typical. With someone like me, with somebody like Eric Holzhauser, I can handle those cases because I've handled them for years. If it's a claim that is uninsured, like a claim for unpaid overtime, which unfortunately in this state has gone through the roof, those are not insured claims. No insurance company is going to pay for your lawyer. I've handled numerous claims for unpaid overtime. And so you would save whatever it costs to defend those claims in outside fees. I've been in all 3 federal courts, northern, middle, southern districts in Florida. I say three districts in Florida. I've argued multiple times in the U.S. Court of Appeals in Atlanta. The only courts I've not argued in, I've never argued in the Florida Supreme Court. I have briefed a case in the U.S. Supreme Court, but I've never had the pleasure of arguing there. I have been in DOA proceedings. I have been in state court numerous times and federal court numerous times. Those are things I can offer to you that, and I don't know who else you've talked to, but I've been litigating, that's all I do, pretty much. I've been litigating cases for years and years. So I think I represent an opportunity for the school district to save a lot of money by keeping these things in-house.
Thank you. Mrs. Fuller?
How do you plan to manage situations when the school board's priorities differ from the superintendent's?
Well, and I know the superintendent and the board will understand this. The law and the professional rules of ethics and my contract would dictate that I am a board employee. Having said that, I realize that this is a collaborative effort. I know we all are here to do the same thing and to accomplish ultimately the same purpose, which is to help kids get an education. And so most of the time, I would imagine that it is collaborative and that there is not disagreement. But if there is disagreement, my ultimate loyalty is to you. That I recognize can create some uncomfortable moments. Been through them, you know. It's I've dealt with uncomfortable moments at my age and my level of experience many times. But that's the bottom line. It's to you. It is to give, not to tell you what to do, not to tell you what you should do, but to say, look, if this is what you want to do, here's what the law says about it. Here are the pros and cons. You're the decision makers, the policy makers. If the risks, you know, I never tell a client, settle this case, for example. I say, here are the potential risks and the strengths and weaknesses. You make an informed decision. But to answer your question, ultimately the board. And if I can come up with a way to help us all get to yes, and some idea that would enable everybody to agree, then that would be fantastic.
Thank you. How do you view the school board attorney's role in providing counsel to individual board members? And how would you handle requests from individual board members?
represent or would represent the board as a whole. But each one of you is a member of that board. Each one of you as a member of the board has every right to call me any time of day or night, any day of the week, and ask me questions related to school district business. And as a member of the board, I have a duty to you to respond to that and to advise you. I don't represent or would not represent a person individually against the best interest of the board. I can't do that under the rules of ethics. But I also understand and I realize there's never going to be a time when 5 people, any 5 people, are going to agree on everything. I've been married for 25 years. My wife will be the first to tell you, 2 people don't always agree on everything. So I understand that. And I think I can walk that. It is a challenge, but I think I have the personality to be able to do that. And I realize that agreements or disagreements, everything aside, everybody in this room has the same interests at heart. And that nobody is going to be, I don't think, act purely out of spite or for a reason that they don't think has anything to do with achieving our objectives. So to answer, I guess the short answer, which lawyers never give, the short answer is I have a duty to each one of you individually to talk to you, to advise you, to tell you things that you ask me about. It is not my place to tell you what to do or to urge you to do one thing or another, but to say, here's the law, here are your options, here are the pros and cons. Beyond that, I'd rather stay out of the rest of it. It is not my place. So,
To tag on to that,
yes.
would we expect attorney-client privilege as individuals with you?
I would have to look at that. Candidly, I don't know the answer to that question. It is a good question. And I don't shoot from the hip. I hate that. I will be the first person to tell people if I don't know the answer to a question because I feel secure enough in my own skin to be able to say that. But I know how to find out. So I don't know the answer to that question. It's whatever the rules of ethics would dictate. Okay. Look, if you told me, heaven forbid, that you've got a bomb in your purse and that you're going to go to the local high school and detonate it, there is not going to be any privileged communication there.
Mm-hmm.
If you tell me that you're going to cause harm, I think I have a duty to reveal that. But I really would need to look at that. Okay. And I'm sorry I don't know the answer off the top of my head.
No, that was a good answer, thank you.
Ashley, I didn't hear what your question was, I'm sorry.
Just, I went a little bit in depth and asked about attorney-client privilege for each of us,
Thank you.
which is kind of what that question was.
Yeah. Just give me 1 moment, please.
Sure.
Okay, my question, I think you've pretty much covered it already. It's how do you ensure that you remain the school board's attorney and not part of the district team, which I think you've covered. How would you remain objective when dealing with legal issues?
Well, I have to do that now. I really do. It can be difficult to do because I'm an advocate. When I'm involved in litigation, I'm an advocate. But at the end of the day, I have to be able to tell a client, whether it's a school board or the general counsel of USF or general counsel of the Department of Corrections or whoever, here's the way this case shapes up. Here are the facts that we've developed. Here's the law. here are the potential concerns, here are the strengths and weaknesses. And so I do have to try to do that. That can be a challenge. But again, ultimately, I look at the superintendent's role and the board's role as being a team, not always on the same page, I know. And ultimately, I'm yours, not his. But at the same time, I think it is very important to have a collaborative relationship with the superintendent and the other members of senior staff.
Thank you. Okay, that gives me the long question, so here we go. I'll read through the whole thing and then I'll go back and do it individually because I don't expect anyone to remember all this. Okay. As a school board, we deal with a wide range of legal issues unique to education law. I'm going to go through a list of issues you can expect to face if hired. How many cases have you previously handled relating to, and now here's my list, ESE students and the development of IEPs, issues pertaining to student due process, I'll go back through these, bringing or defending against Section 1983 civil rights actions, student discipline issues, the McKinney-Vento Act for unaccompanied children, educational accommodations related to disabilities or other special needs, issues related to FERPA, the Federal Education Rights Privacy Act. So what the question is how many cases have you previously handled related to these things? The first one being ESE students and the development of our EPs.
Okay. Cases as in lawsuits, beginning with ESE IEP 0. I've dealt with the issue, but fortunately, not a lawsuit. And I've dealt with the issue of the question of ESE and IEPs multiple times. Due process. Student due process, candidly, none. Due process, but I've handled many due process claims which are brought under Section 1983. Lawsuits for violations of either substantive or procedural due process.
Want me to go through the next one? Is bringing or defending against Section 1983 civil rights actions?
Countless.
Have
I've
you
got
brought them or defended?
always defended.
Always defended.
Always defended. And I'll tell you, I have, because I worked at the Attorney General's office and cut my teeth at the Attorney General's office, I've represented the Florida Supreme Court Chief Justice in his official capacity. Okay. I have represented the former head of the CFO, Tom Gallagher, in his official capacity in a Section 1983 case. I've got Section 1983 cases right now at the office, multiple. So numerous, they're all in federal court. If they try to bring those lawsuits in state court, I'll remove them to federal court because I like federal court better. Student discipline.
Before you
yes.
go on, you've quoted numerous, countless 1983 cases. Have you handled any with the school district?
I'm trying to think.
Dealing with students or school district related ones?
Right, and I'm trying to think if let me make reference to, I provided a list of representative matters, and let me remind myself. I don't believe so, not against the school district. It's funny because Section 1983 claims can run the gamut. They can be anything from a First Amendment, I want to pray at the flagpole, no, you can't do that. It can be that. It can be an employee says, I got fired because of my religious beliefs. It can be a kid who says, a teacher abused me or mistreated me. Those can all be Section 1983 claims. And one's a due process claim brought by the kid. The other ones are First Amendment claims, and it is a vast array. So I've handled a ton. And so I'm familiar with, in Section 1983, let's suppose you are personally sued in your official capacity, or the superintendent, more likely. I've got an appeal in the 11th Circuit Court of Appeals right now, where we moved to dismiss because of public employees being sued because a foster child got hurt. And they're saying you shouldn't allow them to stay with grandma. They're suing this person. We moved to dismiss based on what's called qualified immunity. The motion to dismiss was denied. We're now up on appeal in the 11th Circuit. So 11th Amendment immunity comes up in those cases. Sovereign immunity often comes up, not in those cases, but in state court claims. And 11th, not only qualified, but 11th Amendment immunity comes up. I've lived that stuff for years because I've done so much public sector work. McKinney, I'm not candidly.
Let me go back to student discipline.
Yes, ma'am. Discipline, I have been talked to about student discipline, but a lawsuit that involves student discipline, no. McKinney, I'm terrible with names, so I'm trying to remember what exactly the McKinney Act dealt with. I think it's safe to say I probably have not dealt with that.
It's unaccompanied children that may come here from another country that don't have a legal guardian to
Okay.
represent them. It's who signs for them, who's their legal representative.
I've never dealt with that, honestly. I think I could get up to speed on it pretty quickly. I think I've got the firepower to do that. But Section 504, I've got a lawsuit going on right now in federal court involving 504. FERPA, I've got a threatened lawsuit going on right now over the school bus video. And we told them to go pound sand. We'll see if they come back, I think. I think they'll probably leave us alone, but we'll see.
Let me back up.
Yes,
On the ESE students and the development of IEPs, is that because in Nassau County, the school board attorney handles that? Is that?
Well, they've got in-house folks who, sort of gurus. You become gurus on
I mean, would they be going to the school board attorney in Nassau County, though, since you more or less, as I'm gathering, do the labor and employment, kind of like we use Eric Posthauser here? You're doing the labor and employment law, and the school board attorney is doing that side of it?
I do that. I do other things as well.
Okay.
A lot of times, honestly, Lynn Hacker will give me a call. Because we've known each other for years. And we'll bounce things off, and it's sort of a collaborative thing. What do you think about this? What about that? And, it's a small county.
Yeah.
I'm from there. Everybody knows it.
We understand.
So you know how that is. So he and I, on that and other matters, have, worked on stuff before.
Okay,
It
thank you
doesn't
so
sound like
much.
he's not full-time, so you're.
He's not. I think one of his partners does board work for union, which I've represented union in some litigation. But he does, in the union, I don't get calls outside of the litigation.
Thank you.
And just to clarify, you said that you have dealt with issues, just not had any lawsuits on it.
That's
Right.
correct.
Okay.
That's correct.
I just wanted to clarify that. My question is, how would you expect to interface with other state and local government agencies in your role as school board attorney?
Oh, wow, okay. And have. Well, I'll tell you, for example, somebody has a Title IX complaint, the girls softball team's getting short shrift. Dealt with it. And the question is, how, the football team, the quarterback club, they're draining the community of all their money, and by the time it gets to girls softball, there's nothing left. Everybody's weary of giving. So what do? And then they file this complaint with the Department of Education and OCR. I've assisted a county with Title IX compliance. I've responded to OCR on a complaint. So that would be a potential area. Another potential government agency is the Florida Commission on Human Relations. They're sort of the state version of the EEOC. If somebody files a charge of discrimination, they may investigate it. I've actually represented the Florida Commission on Human Relations in litigation because they were getting sued, ironically, for discrimination in employment. We represented them in a couple of cases. You prepare a position statement. You interface with people there. Same thing with the EEOC, Department of Labor. So I've done that by virtue of what I've done over the years. So I'm used to that. Of course, at the Attorney General's office, I did that all the time because I represented state agencies. So hopefully that.
Thank you.
What types of cases have you routinely handled for school districts in the past?
Okay.
You've already dealt with some of that, but more specifics.
Okay. And I have, and I understand that you've got a vetted list of questions. What I have done is to provide a list of representative matters that I've handled in litigation on behalf of school entities, whether they are school districts or universities. I have currently 2 cases that are pending in federal court. One that involves the University of South Florida, that's on the list, and another that's the Union County School District. So I have listed, in one case, it's a Section 504 case brought by a student against the University of South Florida for accommodations and failure to make accommodations under the Rehab Act. Discrimination under the ADA, I had a federal case against a school district for that. A case against the school district for violation of the Fair Labor Standards Act for unpaid overtime. These were all federal cases. A lawsuit against a school district for whistleblowing, unlawful termination under the Whistleblower Act, and for unpaid overtime. Another case against a school district for unpaid overtime under the Fair Labor Standards Act. Again, those are all claims that are not insured. So these are the types of claims you have to pay out of your pocket to hire a lawyer. A case against the university brought by a professor who didn't get tenure, claiming that she had been denied tenure because of her race. A case brought against the university by a professor claiming she didn't get tenure because of her gender. A case brought by against the University of Central Florida in federal court claiming sexual harassment. Another against UCF brought by an employee claiming wrongful discharge based on race. Another one brought against FSU by an employee claiming that he got terminated because of disability and we didn't accommodate him. He couldn't come to work forever. And it's like, what do you do? School district, the state court, the school district, this is part of a dying breed, a teacher on continuing contract. How many of those do you still have? Probably none. Continuing contract, she brought a lawsuit saying that she had been terminated based on her race. That was in state court. She brought it under state law instead of federal. A teacher who said that the collective bargaining agreement with the university had been breached. She went to arbitration. She tried to get the arbitration award set aside. I handled that. Multiple disciplinary hearings with instructional and non-instructional. And I know that the non-instructional folks, it varies from county to county because 10-1260 says it's governed primarily by the collective bargaining agreement or in the absence of that, school district rule. So some districts, I think, they're actually, believe it or not, some school districts that don't have a unionized workforce. So they can, in that case, I had a.
In Florida?
In Florida. Union County. So I actually had a board hearing to discharge of a non-instructional person. Most of these, frankly, are instructional folks where they have a DOA hearing or before the board itself. And then usually for the non-instructional folks, you're looking at a grievance that goes to arbitration. So those I've handled, and I've again provided a list of those for you. Hopefully that answers.
What do you think makes you the most qualified to be the Clay County School Board Attorney?
I can't speak to anybody else's qualifications. So it wouldn't be fair to them. I can tell you why I think I am qualified. I think I've demonstrated that my knowledge overall of the law concerning education, and there's not a soul who can sit in front of you who says, I'm a guru on all of it. If they tell you that, they're not telling you the truth. I'll tell people, if a lawyer can guarantee you something, run. Because, you can't do that, and be honest. But I have been board certified in education law, which does demonstrate objectively that I passed a day-long test on soup to nuts of everything. I am board certified in an area as well that if you're like every other school district in Florida, and I have no reason to believe you're different, if you're like any other major employer in Florida, I have no reason to believe you're different. Labor and employment law is probably, based on the court records, it confirms what I think. Labor and employment law is what you deal with more than anything else. I didn't see a bunch of bid protests. I didn't see a bunch of anything else. Labor and employment, I saw, and federal civil rights laws. I'm board certified in that. I know of 3 people in the state, 3 people, who are board certified in both. I have the litigation experience to handle these things for you. To the extent there's not insurance, to the extent that you want it handled in-house, I can do it. I've got litigation experience in civil rights, employment cases. If I can figure out some of the convoluted federal laws on employment, if you have somebody who wants to sue under 119 because you didn't give them a document, I can handle that too. I can handle labor matters. I cannot handle the impasse. I don't believe I can do that. If you got something going to arbitration, been there, done it many times. And I can save you money there. And if it's outsourced, I can provide this board the benefit of my personal experience having been in the trenches and doing it.
Thank you. I don't have any additional questions, so I will defer to the rest of the board. Mrs. Studdard?
It looks like we may be getting to the phase that we have been in when Fleming Island was first in that scene. We now have a little area up around Oakleaf that's going boom. And so at some point, we haven't built any schools lately, but we went through years of building a school a year and so forth. And in that, we get into kind of an area that we haven't really been into a whole lot in the last, recent past. As far as land contracts and contracts of, architects, engineers, land, dealing with builders and all that. Have you had any experience at all with that kind of law?
Real estate?
Real estate.
Honestly, no. And as far as contracts, being able to draft or decipher contracts,
Right.
sure, I do that.
I mean, that I
But in a different arena. So
I mean, and I don't, I know like labor and employment is big, but there's a lot of other things that our
Understood.
attorney does like, you know, buses, our buses, either, you know, what can I say? The deeds on land, the IEPs, you know, all the little things that we go through kind of on a day-to-day basis, because, I mean, we do have Mr. Brodsky and we deal with Eric Holzhauser, but there's just so much on the day-to-day that a teacher's calling about a custody, can I, you know,
Sure.
all those, there's a lot of what you might think of as busy work, but then we get into some pretty serious things, and I'm just trying to see where you're.
Well, I can tell you, to answer your question, if it comes to, and I'll say this, there's not going to be a soul who can sit in front of you, who can profess to be expert on all those, on every issue that comes before this board.
Right.
They can't, which
I mean,
means somebody is.
We've had things such as discussion on a girl not being able to wear a tuxedo in a yearbook photo. I mean,
Sure.
you really want this.
Oh, sure. And I understand, like with, my wife is statewide director of foster care for Florida Baptist Church. I kind of went through graduate school with her, and between representing DCF and hearing her talk, you know, I understand some of the issues, I mean, custodial issues, for example, you know, but there should be an order. Custody, if a child's been taken into foster care, a circuit court judge somewhere issued an order saying, this is what happens to this child. Here's the placement decision, here's who has custody, physical custody of that child. If we don't have that order on file, we got a big problem. If we do have the order on file, then we simply reference it. You know, an example would be, well, Daddy shows up to pick up
Right.
John.
We get a lot of that.
Daddy wants to pick up John. Well, does Daddy have the right to pick? Now, he hasn't been TPR'd. His parental rights have not been terminated. So he's still legally Dad. We need to know if that child's been placed in foster care, say through my wife's agency, you know, with a couple. We better have an order on file that we can make quick reference to say, John can't go to Dad. If we don't have that order, we got a problem. If we've got the order, what we do is pull it out and look at it. It's our responsibility to make sure that we've got it. And we know, and I understand, you know, we know he's supposed to go with. You know, my guess is you probably, as hard as this is to imagine, you know, you deal with homeless kids. You know, what do you do with them? Do they go to their home school? You have to bus them to their home school. And I know that those issues come up. When it comes to construction litigation, you know, did they do a crummy job with the concrete? There are only a few people in town who do that, and I'm not one of them, so I can't profess to be an expert on that.
Thank you.
And would.
Thank you.
What additional resources would you expect to be provided?
What I think anybody in this position needs is the ability to research the answer to a legal question. Nobody carries it all around in their noodle. And so this person is going to need Westlaw or something like Westlaw. So they can look at, because you don't want somebody shooting from the hip. And so they need to be able to look at, well, what did the federal court say about this? What did the state court say about this? What does DOA say about this? If it's a bid protest, that's where you're going to DOA. What are their opinions said about this? You know, so that they can provide you advice. So, you know, yes, I would need that. Anybody's going to need that. If it is a good legal research database, that's it. I don't need, I personally, we've got secretarial support in our office, but it's like 3 attorneys for 1 secretary, so quite frankly, with the exception of putting postage on it, I pretty much do it all myself anyway. So as far as secretarial support, pretty low, what's the word, low maintenance. Low maintenance, yes, thank you.
I think we all realize that Westlaw is an important tool. We
Sure.
would make sure that
I'm only wishing I owned Westlaw.
whoever, yes, whoever we should hire
Well,
is certainly provide.
Back in the Stone Ages, when I was in school, we had to use the books. And I look back now and I think, how in the world did we do? And I clerked for a law school, I went to school in Macon, Georgia, and I clerked for a law firm there, and they had a little computer in a room that remained locked.
Oh,
And if you wanted to get into Westlaw, you had to go to like one of the senior partners and say, man, please go to Westlaw. And here's what, and they would unlock, they'd have to find the key and unlock the door for you so you could get in.
Well, don't get me wrong, I don't want to read it. I want to read it so everybody has to buy the licenses from me.
got it.
I don't blame you for not wanting to read it. I didn't want to read it half the time either, but I have no choice.
Ms. Bola, did you have a question?
Yes, I have a couple of questions. As you were talking, it was like, but. Contracts. Ms. Studdard mentioned something about buses. Just using this as an example. We have a GPS system right now in our bus. We are talking about, are we going to keep this contract or are we going to resign from this contract? However you'd like to say that, drop the contract. Do you have any, what is your experience in contract law in that respect?
Well, in commercial contracts, I don't. What I have is experience with contracts in the employment setting. And an example I gave was with this, an example I gave earlier was the employee who says, look, I'm being sued by the SEC, and I have a contractual right to indemnification from the company, that is a blank check to my lawyer to represent me in this SEC proceeding. And so, yeah, I draft non-competes and stuff like that. So contract interpretation, contract drafting, generally, yes. Commercial litigation, commercial contract drafting, have not done that, but it's the same principles that are involved. It's a matter of what does this word mean in this phrase and so forth.
Or what, how could, whatever.
Yeah, often it's, do I have cause to terminate it early?
Bingo.
That often, it probably, maybe what you're looking at. Do I have good cause for an early termination of the contract?
Right.
And, that's going to be a case-by-case analysis, but that analysis is, in a lot of contracts, pretty straightforward. I can see where there would be, if it's a contract to provide microchips that meet certain specifications, and is there cause to believe that they didn't, I'm going to need some help from the IT folks, but the same basic principles from my perspective will apply.
Okay. The other question that can I just keep going? Okay. The other question that I had related to it, and I can't think of it. In a situation where I'm a former teacher, and we had situations where we had a particular family, a father, who he just did not approve of what we were doing with his children, but he would bring his children to school every day and would yell at the people in the classroom, would yell at the people in the front office, would yell at the people and threaten and call the school board repeatedly. We finally got an injunction to keep him at least across the street because physically we were somewhat concerned about this man. Activities of that nature. I mean, the word that I wrote down was trespassing. And basically, if he came across the street before or in between the school, during the school hours, unless he was picking up his child he would literally come in and tell us that he was picking up his child, and we'd say, we'll bring him across the street to you. It was that bad. Any experiences of those, of that nature, anything like that?
That's pretty specific.
It's pretty specific, but I'm just, here again, it goes along the lines of the type of day-to-day that Ms. Studdard was talking about. It's like, we deal with the questions about IEPs and children's rights. We deal with the questions of employees' rights. And it's not so much necessarily in an employee environment, whereas it's a contract environment, you know, are my rights being violated because I didn't get that extra hour of pay or something. It's more of the day-to-day operations of the school where, let's say, the principal has to call you and say,
Sure.
I've got this guy,
Right.
now what do I do?
Right.
That's, I guess, and that's what I'm trying to bring into it. It's not specific, but it's those types of day-to-day things.
Right. And that's what I referenced earlier, I think, the collaboration
Mhm.
between the board and the superintendent, because I'm most likely to hear from about that through the superintendent's staff, not from you,
Mhm.
but through his staff or the principals or whatever. And we're all on the same team there.
Mhm.
It's a pretty simple fix what you're describing, because what I do is go right down the street to the Clay County Courthouse, and I ask for an injunction, and that is not a difficult thing to address. In the world of litigation, that's a really sort of the
That's what we did.
newbie, that's the newbie lawyer you send down there and go, all right, look, get us an injunction, you know, I'll talk to you in an hour. So that would not be any problem at all. Yeah, compared to the kind of litigation I'm used to, yeah, that's a simple fix. And I can tell you, because I pretty much work all the time anyway. You would all have my cell phone, everybody could have my cell phone. I'm available all the time. I mean, my wife does the same thing. Sorry?
We have a certain.
Well, I'm used to it.
You don't understand.
I'm used to it. That's the nature, you know, and most of the time, the emergencies come up on Friday at about 4:30.
Yeah.
No, I had a call 2 days ago. Well, I think it's public record. Yeah, it is public record. A teacher in a school district was drunk in the middle of the day.
Drunk, we understand.
Drunk in the middle of the day. So I get these calls, and it's like, when I get them, it's not, here's what we're seeing in the hallway. It's, we're at the clinic. We're about to have the breath test. You know, I'm used to that kind of thing. Because we don't necessarily plan, we never do, we plan for the worst, we hope for the best, but there are always those things that pop up. You know, spur of the moment, you need an answer, you need it now. I'm used to it. So, and I'll tell you a story without belaboring it. My dad was a lawyer. I was going to practice law in Callahan, Florida with my dad in the sticks. He died right after I finished law school. Never dreamed I'd be working for some national firm because, again, I grew up out in the country and I just, personality, I don't really see myself that way. When I first got licensed, I hung a shingle in Yulee, Florida. And I did a little bit of everything. So way back in the Stone Ages, I did some of that family law stuff. And I survived. But, so I've had some experience. I know basically, you know, what we're dealing with on that. But at any rate.
Ms. Gilhousen, did you have some questions?
I do. Tell me about your board certifications from the Florida Bar. We talked about that a little bit. But tell me specifically how you see the board and the district benefiting from those certifications.
The education law certification, of course, that is directly related to the work here. And what they do, I'll tell you how that, because I got my labor and employment law certification first. I guess maybe I'll walk you back. I'm on the executive council for Florida Bar's labor and employment law section. I've spoken at the certification review seminar, which happened yesterday and today, and I'm now the CLE chair. So we had it really set up nicely where you have study guides, study materials, there's a CLE, 2-day seminar. You take the seminar, you have to apply and show that you've got nuts and bolts experience. Those applications are then reviewed, that you have to prove that you have significant experience in this area. And that's vetted. And then once you're approved there, judges, lawyers get called for reference. Then you're approved to take the test, a day-long dreadful thing, and you get tested. The education law certification is a more recent certification. We have a labor and employment law section. There's not an educational law section in Florida Bar. There's only a committee. I say that because it's basically, rather than a seminar and a study guide and all these things, they give you a list of topics. And then you, on your own, crack the books, and it's self-study. And it's everything from the Sunshine Law to federal grants to everything in between. And it's a day-long test. The education law, I think, is beneficial. There are only 51 of us in the state who are board certified. I'm one of those folks. It demonstrates that I have substantial experience, nuts and bolts, and that I know enough to pass this dreadful test. The labor and employment law, again, I think is beneficial because so much of what comes up in any organization of any size is that. And more so, and this is why I say Mr. Broski has such a difficult job, because in the school board setting, it's soup to nuts, it's everything. You've got state employment laws, you've got federal employment laws, which everybody pretty much is subject to. But then you've got union activity, union issues, and you've got constitutional issues, due process, First Amendment, what have you. I bring that to the table, and that is something I think that the education, the labor and employment certification helps.
Can I keep going? I see in your application that you have the AB preeminent rating from the Martindale-Hubbell.
Yes, ma'am.
Can you explain the process for obtaining that rating, how it benefits your clients, and what that designation says about you as an attorney?
How does it doesn't benefit my clients at all. What that is, it is a survey. Martindale-Hubbell is an old legal directory, probably the oldest, and they will send out surveys periodically to attorneys and judges about attorneys. And the survey will basically ask attorneys to rate other attorneys and judges to rate attorneys. The V deals with professionalism. If you don't get good marks on professionalism, you don't get rated at all. That's what the V stands for, and I'm not sure why they choose it. The A is, as you would imagine, is like school. You can get an A, B, or C. I don't think there's anything below a C. And now what they've started doing is they've also given a numerical score. So like a perfect score is like a 5.0. That's what I have. It doesn't benefit clients. I think it's more of a reflection on the attorney. And I think it would be the same with best lawyers in America. It's sort of the same idea.
You mentioned this before, but let me get a specific number from you. How many school districts have you represented?
Nassau, 4. again, Nassau is sort of the gamut, it's more the gamut, including labor and employment, union labor and employment, St. John's labor and employment. Santa Rosa has been some labor, not employment, and Title IX compliance.
Thank you. I do have a question. I haven't asked any, and it was something you said, the district. And you have a firm that you work for, you said you work for a national firm.
Yes, ma'am.
So when you come to, if you come to work for Clay County, you'll be comfortable with a non-compete that you will only work for Clay County?
Oh, sure.
Okay, that's,
Sure.
when you talked about the national firm, I thought, this, you know, just want to make sure that you'll be our full-time in-house.
Oh, yeah, that's,
Okay.
If I may, I was just going to say, if I may back up to that question, that's exactly the question, or the similar question I was going to ask. Why? Why do you want
That's a
a
good
major
question.
firm to come to Clay County?
that's a very good question. I'll tell you something I've told my wife for now decades. She was pre-med, she discovered psychology late in her college career, switched over to psychology. I said, why in the world did you do that? Because then she went into social services and she got a master's degree from UNF, and her first job was like $19,000 a year, and she was magna cum laude. You know, she was magna cum laude in undergrad, she was summa cum laude in graduate school. She made straight A's. And she's like making 19 grand a year, killing herself. And I realized over the years, she did it because she wants to do good for kids, which is why people go into education. I don't think people go into education to make a lot of money.
I can assure you that
And
that's
yeah.
not the case.
And I can tell you, I'll tell you this, I know what the pay range is, I will take a substantial pay cut. I'm not here for the money. I'm here despite that. And my wife and I have talked about that. And she is fully supportive of that. And I'm interested for the same reason she does what she does. And the same reason teachers become teachers. And it's a chance for me, you know, the older I get, the less money means to me, quite frankly. I've got a Harley. I'm happy.
You got it all there,
Yeah.
man. You
I'm
have
sorry?
jet skis too?
No, I'm too fat. But, you know, I'm not doing it for the money. I'm not doing it because it represents the next rung on success or stepping stone to the next thing. I'm interested because, honestly, I've really enjoyed the people I've worked with over the years. I know there's always a pain. There's always somebody to be a pain. But I think the vast majority of people I've had the joy of working with over the years in all of these school districts, I've been there because they want to do something good, and they're good people, and they want to give back. Outside of my immediate family, the two most influential people in my life were a 7th grade English teacher who was like a drill instructor, who just beat me over the head, and a college professor. And both of them could have made a whole lot more money doing something else, but they wouldn't have impacted me. And so I enjoy the work. It gives me a chance to do what I like doing in an environment that I think I would enjoy. It would be challenging because there is a vast array of stuff that you got to deal with. But I would feel like I can then go to my wife and say, you know, I'm doing some good too. You know, so that's why I'm here. That's why I'm interested.
Is there any further questions?
I have one more.
Mrs. Studdard?
I didn't know whether to ask this or not, but I'm curious, and
Sure.
these girls know, I'm curious about something, I'm going to ask about it. On the one packet that you gave us,
Yes, ma'am.
on the back where it says the Florida Bar, I just don't understand this, and I don't want to ask something I'm not supposed to ask, but it's written here on this paper, and I just don't understand it. It says, no discipline, incapacity status, 1994, 95. complaint dismissed 10/1996. I guess my
Oh,
question
yeah.
is, have there been some complaints against you?
No,
And
here's-
what does this mean? I'm not a lawyer.
Okay, I forgot about that. I had medical problems back in 1994.
Okay.
And what I did without injecting, I don't care. You know,
I mean, I hate to ask, but it's.
yeah,
there. It's
and
like-
here's what I did, because I thought that it was the,
Excuse me.
District school, you're not required to
I know,
answer that
I know.
Do
question.
not have to
If you
show
answer
us
that
at all.
question, it's of
This
your
is-
own free
this is
will,
private.
No.
not the board.
No,
I understand.
If it's something I'm
You
not
don't-
supposed to
No,
ask,
you don't,
you know, I don't
have
know.
to.
I know, and I don't mind, and it's, I don't have to go into detail about it.
No, please.
I
don't.
voluntarily went inactive because I thought it was the prudent thing to do for the sake of my clients.
Okay.
And then once I got that addressed, became active again, petition. So it was through a petition process,
Okay.
and that was the whole thing.
And it,
But that's
and it was
fine.
94, I mean, long time
Oh,
ago.
yeah, and that's, look, you didn't know why.
I mean, I just read it and I
And,
thought, what does that mean? I don't know.
Okay, understood. You didn't know why, and I know you didn't know why.
And I don't
and
want to know the
volunteered.
details, I just
Okay.
wondered what that was. So is that the only complaint that's been against you with the Florida Bar?
Yes.
Okay, thank you.
Well, and that wasn't actually a complaint, that was something that I did
Oh,
on my
so there's been
own
no complaints against you with
initiative.
the Florida Bar?
Not to my knowledge, I
Okay,
think I
well,
would.
let's go. Thank you, sir.
Well, did you have any questions of us?
No, ma'am, other than just to say thank you. I know it's a lot of fun to sit here for 2 days, but I
Oh, we
appreciate your
just had a
time.
ball.
We're learning so much.
Look, I've interviewed numerous attorneys for associate positions, and it's like, oh, no. So, I
They all
appreciate
speak
your
the
time.
same language.
I appreciate your time.
Thank you so much.
Thank you.
Appreciate your time. Appreciate it.
We will be meeting on February 2nd where we will have discussion and possibly take some action. So after that, our Mr. Brodsky, our Assistant Superintendent for Human Resources, will get in touch with you. But we thank you very much
Well,
for
thank you.
coming and interviewing with us today and taking the time out of your very busy schedule.
Hopefully this is the last one, so you guys.
It is.
Yeah.
It's freezing in
And
here.
warm up.
Yes.
Thank you very much, it's very nice meeting you.
Well, I joked with the superintendent
Oh,
that
don't
he
adjourn.
had
Okay.
provoked this other girl.
I have to ask you.
Country real fast.
So
So I live in a small town.
Thank you so much. Is Archie still at?
You know Archie? Yes.
Oh, yeah.
Thank you so much.
Where do
Thank
you
you.
know each other from?
Thank you so much.
We used to go to see, he was music director. Hi.
Okay.
Thank you so
Appreciate your
much.
time. Thank you so
Sorry to
much.
hold y'all up on a
No,
beautiful Friday.
You're not, we're scheduled, so we're good.
So,
Yeah.
I appreciate it.
Thank you.
So you know Archie from Hialeah?
From Alberta. Well, I used to live on the west side of Jackson, and I went to a church where he was the music director. And he lived right down the road.
Oh, I'll have to
Yeah,
tell him that.
He may not remember me, but I went to both class back when Rick Baldwin was there. I don't know if you know
I
who he
don't
is.
know.
But he left, we left, I know there's a church out
Well,
there.
wait a second, we're not done. I just adjourned.
Well, I saw that on your resume, you said Trinity Baptist.
She didn't adjourn.
Trinity
Oh, I
Baptist.
grew up going to school there, and I went to Trinity Baptist years ago. Probably, oh, on the west side.
That's it. That's it. When you were Trinity Baptist, I'm Lutheran, so I didn't go to Baptist churches, but.
It's a big school, yeah.
Yeah, I went to grade school.
Oh, you went to grade school, okay. Awesome.
I really appreciate it.
This was wonderful.
Yeah, he's really.
She said we're not dismissed.
Grown up.
Why not?
Thank you.
Thank you.
Yes, sir. Thank you so much.
Appreciate it.
No.
All right, so not yet, because we're not adjourned yet.
Did not.
And I didn't want to adjourn unless you,
That's
until
right.
we had decided if you want to have discussion or not.
There's one item that I wanted to discuss if we can. I would like to propose that we follow the same method of choosing an attorney as the county commission did. I like that they didn't have a lot of discussion about the individual candidates. I think that when we did that previously, it took a detour that I think we all wish hadn't happened. So the way that the county commission does it is they each pick their top 3 candidates, number them 1, 2, and 3, and then the candidate with the lowest number becomes the recommendation for the attorney for the board to
For
vote
the
on.
lowest number?
Right, because you
Grade
rank
of
1, 2, and 3.
Grade action.
So I know we can't vote in a workshop, but would that
Correct,
be
we
something
can't.
that we could come to consensus about process here, or?
And I'm the newbie here, so I'm gonna throw up my hands and say, having hired people in the past, and having worked with people to hire people in the past, and sometimes it being a committee decision, sometimes it being my own personal decision, I'm sort of at a loss as to how we discuss this on the board floor, and how I discuss what I chose, or who I chose, or why I chose a particular, if you want to say rank versus something else, and that this, I appreciate this. I appreciate the rubric that we got, but I'm sitting here going, whoa, this is, some of the answers are not necessarily gradable, if that makes sense to you. It's not I can't say, oh, this candidate is a 1 because, or this candidate is a 4 because they are each individual people, and they bring each of the 4 candidates that we have brought awesome information to the floor or to this process. And I'm sort of leaning towards that route. I'm assuming there will be some discussion. I don't know if there's an automatic, if you're suggesting that, okay, if it's the 1, 2, 3, 4, automatically the person who gets the lowest
We still need to vote on it.
wins, or what, or if that's just sort of how we did the 5 when we started with the first group of them. I'm just throwing that out as discussion as well. I'm not saying this is exactly how I feel or not. I just feel awkward, I guess, using a straight rubric for answering some of the questions that came, because they all had different answers that were unique to each of them. And they weighed differently, I guess,
I think it could
in
be,
my mind as well.
I think it could be a great starting point, because it could be that, it could end up that we all have the same, if we all had the same person with the lowest number of points in that kind of scenario that you're talking about, or if we narrowed it then down to 2 people, it could be either A, we decide to do a second round of interviews with different questions, or more in-depth kind of, less questions, but more, how would you handle this scenario, and then they have a certain amount of time to answer, or something like that. So I could see that developing. Or it could be that we then have discussion on the strong points of those candidates, not focusing as much on the weakness. I think that I've also, in hiring people, I think what you're, if I may, I think what you're kind of dancing around is it's difficult in a public setting to have negative discussion on someone and tiptoe around that lawsuit.
Truly that, yes.
Tiptoe around that lawsuit line. Right, and we don't want to.
That's just, and that's the idea.
And
It's not-
so I think that we could come up with, that could narrow it down to maybe the top 2 candidates, or the top candidate that we could all say, these are the strengths on, without having to walk that line.
And you just came in the middle of a discussion. Ms. Gilhousen, do you want to repeat what you said? Sorry, Ms. Chairperson.
For Mr. Davis?
No, were you in here when she was saying, yeah, I was in.
I was in that, I heard.
The process that I would suggest is that we follow the same process that the BCC does, where each board member scores their top 3 candidates as 1, 2, and 3, and then the candidate with the lowest number of points becomes your front runner, and that would be the recommendation for the board to vote on, whether or not to hire the top candidate with that score.
Versus going with the entire rubric.
Okay.
They don't really care for the rubric because some people, they felt,
It didn't, well, and for me, it wasn't, the rubric in a grading situation is awesome, because you can say, I see proof of this, 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 and this, and this, and I may see proof in a candidate that someone else doesn't necessarily see that same proof. Does that make sense? It's not, I can't pigeonhole it. That's where I'm coming from. I can't pigeonhole some of what I'm seeing.
I think for me, the rubric puts me in a position of having to weight each question equally, and that's what I was trying to communicate yesterday, that for me, not each question is equally weighted. Some are much more important than others. The answer, so for instance, someone who said, like, they couldn't answer any of your lengthy question. If someone couldn't answer any of those questions, that weighs far more heavily on me than the relationship between, believe it or not, than the relationship between the board and the superintendent and the attorney. Because in the day-to-day setting, that's going to be far more detrimental to the district than would be, not that these relationships won't matter, but they're far less likely to happen than the day-to-day if they don't know what they're doing in those kinds of settings. And so that's why it's difficult in my brain to pigeonhole me in that rubric. Not that I won't use a scoring system and rank all four, to me, grade on each question, each individual candidate on how they answered each question. I will score fairly, comparing them all four with each other, just not necessarily on the same thing on each question.
Mrs. Stutter, did you have a comment?
Well, the three of y'all are in agreement that that's the way you want to do it, so it's fine with me, you know.
And I mean, and within that, and as we discuss, because we'll end up discussing it, we know we will.
You know,
But
I don't want it to be so clear cut that it's, you know, well, this one got this, you know, if there's a couple.
27, 29,
Like,
yeah,
a couple
exactly.
of them, we might need to have some discussion on it, but I do agree that whichever one of you said, I don't want it to just be a show on the board floor, whatever we do.
No, no.
I think we're professionals and we need to act that way.
Yes.
With the county commission, when they did do that, and they had their discussion, how did they do it without naming names? Did they say candidate A, candidate B?
I honestly don't know. We have to go back and watch their meeting to
Yeah,
catch some
we'll have
cues
to
from
watch it.
that.
I don't remember.
Yeah.
They had a different.
Well, I'm the
interviewing
liaison
process,
to the
I know, as well.
BCC, so if you'd like me to, I can find out. I'll be
Yeah,
happy
why
to
don't
ask
you
the
do that?
question. I'll be happy to find that out, because that's a very
Let's go
good.
with that.
That's a good
Exactly,
question.
that's what the majority of the board
Yeah.
wants.
Yeah.
It's our meeting, it's our board, so.
And I have a question from, I don't know who to ask this of, Mr. Bosky perhaps? The last candidate that we just spoke with had done some research about our legal problems, for want of a better word, issues, over the past 5 years. Do you all feel that that was indicative of, I mean, you guys as a board as well, were the numbers that he had indicative of what we've had over the last 5 years? I didn't even think of asking that question earlier. He had said that most of our issues over the last 5 years were labor and employment.
Well, he was
That
talking
was prior
about,
to us.
he was talking about cases though. I
Well,
don't
I'm
think he
saying, well, what-
understands what the day-to-day work of the school board attorney, you know, really, that's why I was bringing out the other things.
That's, and I
There's so many
piggybacked
things
on that,
that's
yeah.
involved in being an
But if that's what was one of the most
attorney.
prolific things,
Yes,
what can we find out about like over the last 10 years? I don't know.
I think what he was talking about, what the point he was trying to make is that he could save us money. Because those cases that we handle externally typically, he can handle himself. So what he was saying is, this is where you're spending your money outside of your school districts. And I can bring that in-house, is what he was saying.
Okay, do you mind if we adjourn?
So,
Or it's not adjourn, but let the superintendent.
Yeah, oh, no, you can go.
Yeah.
Madam Chair, is there anything you need me to do before?
No, you go to.
Yes,
we're
please.
good.
No,
Just-
but as far as,
Yeah,
this,
no,
my understanding is each member's coming up with their own top
Top
10.
three.
You're right, your own,
Yeah.
just coming to the board and having that discussion.
I will
I've got
communicate.
no.
Can we send you an email
Get
with
it to
some?
him before,
Yeah.
like, say Wednesday.
They
But
need
just
that.
remember,
Yeah.
all of our stuff is still public records, so
Yes.
just send him a copy of it. And if we wrote anything in, nobody has notebooks.
I found that right.
I only wrote on that page, so.
I only wrote on the page
So
and
what
I'm so
exactly
scratchy.
am I doing before the
They
board
will get
meeting?
ready.
Okay, so we are going to each email Mr. Brodsky, not reply all, just copy Mr. Brodsky, our top three.
I will,
Is that correct?
Well,
well, I will
for the
find out.
four in order.
I'll find out
basically.
from the county commission and communicate to you,
Can we
Mr.
just
Brodsky.
decide to follow the county commission's model, and then you can communicate with Mr. Brodsky what
Well,
that
I'd
is?
like to
Well,
look
all
at their
of us
model,
know what their
but
model is.
we don't know what their model is, so that's
The
gonna
problem
hard
is we're
for
not
us.
gonna have an opportunity to discuss it before the board meeting, so.
I did not bring my phone in, otherwise I'd just say, let me call Wayne. I mean, quite seriously, because I know that they ended up having, all I know is that they came up with their final five, that they had gone through the interview process of these final five, and that they came probably to the meeting or sent it ahead to Stephanie Kopluzis, those final five and how they ranked. And fortunately, it was a very obvious vote. So,
That was when they were hiring what?
their newest attorney, they just hired an
Just
attorney,
hired.
yes,
Who did they?
Courtney
a
Brown.
woman.
So it's my understanding the board members are going to send me an email with, in ranked order, their candidates.
By when?
1, 2, 3, 4.
By when, Ms. Caracas?
As long as I get, by
By
that morning.
Wednesday?
Is
By
Wednesday
Wednesday?
Thursday morning.
That's
I
right.
would just go back and review the tape.
Yeah, I
because
wanna-
I remember who said what.
And Chris has assured me that it'll be up today, so, 'cause
Okay.
I'd like to go back, you know,
Yes.
this last man is the
And
only one in my mind right now, so.
And what would you like for me to, how would you like that sheet to visually look? Would it be each board member and their rankings, or the candidate and the number?
of points, yeah. I don't think you need to specify each one of us and what was our top three. I think it would be better if it was the top three candidates and what their scores were.
I think that's especially valid, given that everything does become public record. I think it would be nice if we didn't particularly have a person's name attached to, say if I ranked, I think it could alleviate someone coming back to someone personally. I doubt any of these
Well,
four
I
candidates would do
think
that.
also, if we were to hire someone and it wasn't a 5-0 vote, is that what you're thinking?
Yes, that's what I mean. Yes, that's my point. Because whoever is
But-
the person.
but-
I can throw Courtney out there because I mean, Wayne told me he was the only one who did make her the first. It was 4-1.
So he knew.
No, he chose, there were 5
Oh,
people.
he's saying that.
The top 2 people,
And he knew it
he
wasn't-
had the
he
second
wasn't-
person as the first person and Courtney was the 4th person. And she knows that. That was communicated. But it doesn't make any
And I
difference now
think
because
it
she
will
was
make a
hired.
difference.
And he's very happy with that
Thank
legal
you for that
representation,
word.
so. And that's the ideal. It may not necessarily be a 5-0 vote.
Right.
If it is a 5-0 vote, that's awesome,
Well,
but
we know that
if we
we'll
can
able
be
to
happy
work with it.
with the decision that we make, that's the important part. So,
So you're
And
looking
move
at a point system for each one that was the first candidate for each one, they'd be awarded so many points for being first.
We don't need
Just
points.
No
a
points.
1,
We don't
2,
need
3,
points.
4 ranking, and then
It's gonna be
total.
right.
you
1, 2,
can
3.
list, if
We just want 1, 2, 3.
I think just three is
Just
sufficient.
put them in the order of.
Just our
whatever
first,
we
second,
said
third
to you,
choice,
first,
and
second,
that's
third.
it. You'll be.
So you
So
would
you'll
say,
add-
you would say.
Based on the total.
Right.
But everybody's going to vote, might vote differently. Candidate A might be your first choice.
correct,
Candidate B might be your
Correct.
first. Candidate C might be your first choice.
correct.
So how would I
You'll
visually
go-
put that?
You'll just go candidate A, and they could have 5 points, they might have 7 points, because one person might have put them as number 2. So instead of
Oh, so you're
5, they
counting,
would get
if
2.
you're 1, it counts as 1 point.
Right.
Right, right.
Gotcha.
And then, so it would just say candidate A, this many, candidate B, this many, candidate C, this many, candidate D, this many. I think
So we probably need to rank all 4.
I would say all
Yeah,
4
we should
because we
rank all
interviewed
4.
Right
4.
off, or
Yes, right
just
off.
run forward it, so we're.
And then the person with the lowest number of
And like you
points
said,
would be
we
the
wanted
front
to do.
runner.
The one that we would
Another
like
one,
to hire, we do.
It's number
One.
1.
Okay.
If it's not, if there's a
If-
great
if-
discrepancy.
If it's a tie or if it's right in between, then we
Yeah,
might
that's
have to
when-
do 1 and 2.
Yeah.
Okay.
That works. Any other,
That saves you
any other
from
comments?
all these rubrics also.
was there anything else before we adjourn?
No,
All right.
thank you.
We will adjourn the school board meeting of January 27th. Thank you.
I think